When did the South African Social Security Agency realize it wouldn't be able to pay social grants directly, and when was it exactly? That's the essence of what the Constitutional Court hopes to hear from SASSA as they respond to a litany of questions from the Con-Court about their 11th hour agreement to extend the social grants contract with Net1's Cash Paymaster Services. This is the MoneyMakers. I'm Bruce Whitfield and I'm joined by David Lewis, Executive Director of Corruption Watch, to talk about why the court should take back oversight of social grant payments to 17 million beneficiaries. Serge Belmont wants to sue you. My producers heard him make a comment last week in which he was saying, and that man David Lewis from Corruption Watch is saying horrible things about us. What did you say?
Well, he says, and we have received a letter from his attorneys asking us to retract what he claims are allegations of defamation. You know, I think that we haven't agreed to do that.
So what were the allegations? We're not going to repeat them.
Well, he alleges defamation. He alleges we have said that Net1 is a corrupt company, or CPS is involved in corruption. We have said that this is either incompetence of a breadth and depth that is unparalleled, or there is corruption, or there is both. And I mean, the incompetence is clearly demonstrated in the fact that they couldn't fulfill the administrative requirements for issuing a 10 billion rand tender, so much that the Constitutional Court struck it down, and then given 2 years to rectify it by the Constitutional Court, they couldn't pull that off either. You know, and as the court remarked in its original all-pay judgment, these regulations, these requirements have to be taken seriously because they may just be incompetent, but as the court said, they may also be token corruption. They may also be these violations in order to benefit, you know, one or other party, in order to skew a decision in one or other direction. So we want this to be investigated. You know,
you're making an allegation yourself. You're using publicly available documents, court judgments, to assert the fact that there is a legal concern which needs to be investigated.
Well, there is a public concern, sure. Then the court have articulated why there is this additional concern. Look, you know, and indeed, you know, the US Department of Justice took their cue from the Constitutional Court ruling and undertook an investigation, which they've been at pains to say they haven't closed down yet. And South Africans don't seem to have done the same thing.
And that they haven't closed down yet. Does that mean that they're continuing to investigate, that there is sufficient evidence to justify their not closing the case?
I speak slightly under correction here, but my understanding is that the investigation is dormant, and what I hear on the grapevine is because they didn't get sufficient cooperation from the South African authorities in order to conduct it. But they have been at pains to say that while dormant, they have not closed the investigation. Okay. And you know, I would have thought that CPS would have welcomed an investigation, in fact, because you know there are a lot of people worried about this. The public are very concerned about how this extraordinary degree of incompetence has come to pass.
When you make allegations of incompetence, is it allegations of incompetence against Net1, which seems to have been very competent in securing itself a very lucrative contract in order to distribute social grants for a period of time in such a way as they've managed to exclude competitors from the market, in such a way as they have benefited dramatically from this?
No, the incompetence is directed at SASSA and the minister. They were the ones responsible for putting out the tender and for administering the tender, and they couldn't do that competently. They were the ones told to set up another tender, and they couldn't do that competently, despite assuring the court that they had done so, I should add. And so that's, in the first instance, is what has to be looked at, and the court are asking who is responsible.
That's precisely what the Constitutional Court is requesting.
But the court also said in the original all-pay judgment that these things may not just be irregularities, or in layman's language, this may not just be incompetence.
Mistakes.
They may not be mistakes. They may be designed to produce a particular outcome. And so that's what the underlying issue has to be examined as well. And the only people who can examine that really are the law enforcement authorities. And as I say, this is what the US Department of Justice did, and I don't understand why the hawks have washed their hands, seemingly, of this whole business.
Well, the hawks are very busy, David. You know that. They're doing important things, not trivialities like this. We sit on the edge of a momentous occasion in South Africa should, for whatever reason, the social grants not be paid on the 1st of April. It looks pretty much like they will. Simply a brand new contract in place. Net1 will roll over their contract for a period of time. And there seems to be an attempt to get the finance minister to sign off on this particular matter as well, which may be against the law, according to some of what I've read. Give me a perspective on that, please. What the position that the finance minister finds himself in?
Well, let's say firstly that they can't not pay the social grants. No. As much as the sun can't not come up, they can't not pay the social grants. And I imagine that the court and the Minister of Finance find themselves in a very awkward position because, essentially what I understand SASSA to be attempting to do and the Minister attempting to do is pass the buck to them. And, they may pass the buck back and say, we can't make something that is manifestly unlawful lawful, but you take your chances, pay the social grants and see what comes of it. I'm sure they'll say so in much more sophisticated terms than that. And maybe the Constitutional Court does feel it can, in a sense, sanction, kind of condone an illegality. And there is in the Treasury regulations a sort of catch-all which may allow the Treasury to do that. But this would be, truly in contravention of every procurement principle and regulation that we have.
The first imperative is to ensure that the grants are paid.
Yeah,
there's no discussion around that.
Undoubtedly.
Okay. The second one is to find out how the system was allowed to be corrupted, and I use the term loosely, in the way that it was.
Well, don't use the term too loosely. You might get into trouble. Why the system has not worked? I mean, absolutely.
That's better words. I like
and
your
the
words.
system may have not worked because they may be just thoroughly incompetent. I don't believe in one of the biggest public tenders that has ever been issued in this country that you could appoint a series of bid committees backed by officials and experts who could not, I mean, these regulations are not rocket science, how they could have not ensured that at the very least the regulations were obeyed, and they didn't. And so if it's only incompetence, then, heads should have rolled a long time ago, starting with the ministers. If there's something more to it than that, then, equally this needs to be investigated, determined. If there are criminal transgressions, they need to be prosecuted and the law needs to take its course.
In the reality in South Africa in 2017, what are the prospects?
I think there's a lot of there's an unprecedented degree of public anger about this. I actually really do believe that this is the lowest.
Finally, South Africans are getting cross.
They're getting cross. And, it's very interesting to see in our experience that it's about the stuff that hits the poor that people get seriously angry about. Even the rich folk get angry when they see this happening. And I think across the board, firstly, I think South Africans know that there's a social grant system, and it's probably undoubtedly the most effective program that government have ever introduced. And now they know about it, and when they see it treated in the manner that it has been treated, given the importance of it, and given the dependency of a large number of people on it, then I think that this is potentially a bit of a game changer. I know that we've all said that before, but I think that this is about the lowest point.
The game is changing all the time, and we hit new lows all the time as 2017 unfolds into what really this is all about ultimately, which is a political race for power come 2017 and who's going to run the ANC.
Yeah, well, this is always going to be a brutal year, and I think this is a hell of a start to it.
Back to Net1 and Serge Bellemont and the way in which Serge Bellemont has evolved his business to capitalize on the business of social grant distribution. Again, nobody's suggesting that any laws have been broken, not for a moment. Social grants have been utilized as a mechanism for microloans to be extended, for insurance policies to be sold. There's a lot of work being done now by the financial analyst community to try and decipher precisely what's being going on, but it doesn't feel right, does it? I mean, the way in which Net1's business has evolved over the last 10 years, from being the guys who made the chips that go into the credit cards that make financial transactions secure, to be the guys that distribute the tenders, provide the microloans and sell the insurance.
Yeah, I mean, in the days that I was involved in competition law, we used to hear a lot about this kind of stuff, and I'm not really even suggesting that competition law has been broken. I mean, the Black Sash have focused on that issue. We've tended to focus on the procurement issues. But I don't think it makes people feel comfortable. I mean, it doesn't make me feel comfortable, and it clearly doesn't make the public feel comfortable. There is a sense that a privileged place at the point of payment has benefited the other businesses. I see people talking about, I don't fully understand the question of access to biometric data and how that helps ancillary businesses or connected businesses. But it is uncomfortable, and maybe the best way of resolving that discomfort is not to permit that. I think that is wholly possible, but it's not an area that we've been very heavily involved in.
Do we solve this problem by saying to Mark Barnes, okay, you do the job? I mean, the state has outsourced many of its basic functions for so long, and the idea of a public-private partnership is a noble and honourable idea until it's no longer noble and honourable, until the service provider goes beyond the pale in terms of the mandate that they were supposed to deliver on.
I don't know that the public-private partnership is a bad idea. I mean, if it's a relationship with the post office, then it's a partnership. I mean, and I was, if anybody had suggested a year ago or 2 years ago that the post office could do this, I would have been amazed. But I'm really interested in Mark Barnes's insistence that they can do this, which I think is an extraordinary sort of mechanism for turning around the post office, and he's obviously confident that he's advanced sufficiently far in that to take on something at which you cannot fail. There's no doubt about it, and I find that impressive, and I would imagine government should be interested in it just as they are in any other mechanism. I mean, the post office has a very huge footprint, as these institutions do, and so, on the face of it, that would seem to me to offer a viable solution for distributing some of the grants, certainly.
I wonder who will issue the smart cards for that particular tender. Yes. David Lewis, thank you very much indeed. David Lewis, Executive Director at Corruption Watch, on the thorny, difficult and convoluted story of social grants and why we've got ourselves into the dreadful tangle that we've got ourselves into. More stories as the week and the month unfolds. For now, though, do have yourselves a very good evening. Good night.